Good afternoon, dear colleagues. I'm very happy to welcome you at our Modern Arbitration Live project that is supported by LF Academy and Russian Arbitration Center. Within this series of interviews, we speak with leading Russian and foreign practitioners about most interesting topics in the sphere of dispute resolution. Today we have a very special guest here in our studio, Alice Fremuth-Wolf, who is the Secretary General of the Vienna International Arbitration Center. We are very happy to welcome you in Moscow. Thank you very much for coming.
Thank you very much. I'm happy to be here again. It's becoming one of my most favorite cities recently.
Great. We are very happy to see you in Moscow, in St. Petersburg, in Russia. So I would like to talk today about the Vienna International Arbitration Center. You have been the Secretary General of this arbitral institution since 2018. And I know that Russian audience, Russian users, practitioners, arbitration community is very much interested in the activities of the Vienna International Arbitration Center. It's not a young arbitral institution, so many of us know something about, but it's always interesting to learn something new. It's always interesting to know how the things are being developing. Arbitral institutions are now very dynamic, including VIAC. So please tell a little bit about the history of VIAC and also what is the focus of VIAC, what are the peculiarities, and also describe your role as the Secretary General of the VIAC.
Yes, with pleasure. Thanks again for having this opportunity and for being invited to participate in these talks. VIAC was founded in 1975 by the Austrian Federal Economic Chamber, which is a public legal entity under Austrian law. And the aim back then was to create an arbitration institution in an international arena that is specialized on East and West disputes. That was still the unfortunate times of the Iron Curtain, and there was a real need for an independent institution in a neutral country that would facilitate trade between the two sides and also provide a dispute means. And I think ever since that has been our main focus. The CEE, SEE region and CIS region are our main focus of attention, and we have really tried to become the premier international arbitral institution for that region, for international disputes of that region. Originally, we were only founded to administer international disputes, so Austrian domestic disputes were vested with arbitration courts of the local chambers, and since last year we were granted the permission also to sort of administer the purely domestic disputes. So we are quite in a reverse situation that now within Austria we have to promote our businesses, where abroad most people are aware of us. The VIAC is a small regional institution, but with a long-standing tradition. And as you have mentioned, I've been the Secretary General since 2018. Before that, I was the Deputy Secretary General for 6 years. So I've been with the institution for quite some time. And I have seen really development in terms of how institutions are being run, in terms of professionality, in terms of what is demanded from us. You will know for yourself that there's a lot that we need to cover nowadays. But of course, my main goal and my main aim and duty is to oversee the case management. I think we should not forget, with all the promotional activities that we're doing, that we're still there first and foremost to administer arbitration, to really provide advice to parties and also to arbitrators in difficult situations, maybe even in pre-contract phases. In addition, of course, I oversee the Secretariat's work, the case manager's work. I'm here to promote arbitration and also to educate young practitioners, because that's one of my main goals, basically, to increase also the young generation in arbitration and, of course, female arbitrators.
That's great to hear, and it looks like it's very interesting and challenging times when you stepped into this new role of Secretary General. Before we move to VIAC in more details about the rules, I would like to ask a brief question because the institution also depends much on the seat of arbitration, the main seat of arbitration, which is Austria. And as far as I understand, Vienna and Austria is a rather pro-arbitration jurisdiction. So can you briefly describe the approach of the Austrian courts? Because I think it could be interesting and important for the users.
Well, we are in a very lucky situation that, first of all, the law on arbitration is based on the model law since 2006, and then there was another main step in 2014 when the Supreme Court was enacted as the first and last instance for setting aside proceedings, and they even created a special body within the Supreme Court in order only to deal with arbitration cases. I think that has really helped in order to create a reasoning and decision making by the Supreme Court that is very much in line.
Excuse me, both international and domestic?
Yes, both international and domestic. And in the sense of pro-arbitration, I can see from the statistics that most challenge cases that are being filed are evaluated on a, of course, very sincere basis, and when there are infringements of the right to be heard, the Supreme Court is very strict with that. But apart from that, when it comes to interpretation of arbitration clauses, there's the clear sensus of in favor validitatis. So in case of doubt, the arbitration agreement is being held valid, and the quality of the decisions has really risen to a very high level. And also in terms of interferences of courts in pending arbitration proceedings, it's only a positive means of interference in assisting arbitrators in evidence taking or in other instances, or for ad hoc arbitrations in appointment of arbitrators or challenge claims. So the whole environment is really very pro arbitration.
That's very important, and that's very good to hear that Austria as a jurisdiction and the courts are also focused on arbitration and also developing in this sense, providing some new features which are very important for the users.
Also, when the new arbitration law in 2006 and also in 2013 the amendment was being drafted, also the VIAC had a very strong stance in that, and we were participating very much in this. And in order to, enhance this, for many years we have one Supreme Court member in our board. And since then, the natural or, historic hostility between arbitration and court proceedings has really vanished. We see each other now much more as complementary, that for some disputes that is better and for some disputes this is better. And of course the Supreme Court judge is not sitting then in the cases of challenge, but he has a very good contact with his colleagues, and I think just the understanding of how arbitration worked has really improved very much in the Supreme Court due to this fact.
That's great to hear, and I think it's very natural because actually we are here to support each other, the state courts and arbitration.
Yeah.
So that's
friendly competitors.
Yeah, that's great. So in 2018, you have also enacted the new rules, VIAC rules of arbitration and mediation. So recently we met with you in Vienna at the discussions on the expedited proceedings within the working group 2 of UNCITRAL. So please, can you tell a little bit about these new rules? What are the main features? Do you have expedited arbitration, which is the top trend now? Absolutely,
it's a must-have, basically. Well, the reason why we had the 2018 new version of the rules was basically the mentioned decision that I mentioned before, that we are now able also to administer domestic disputes. That was enshrined in the law and also in the rules that we could only administer international disputes. So since this was changed, we also had to amend our rules, and we took this opportunity to try to bring in some features that had come up over the past 5 years. But in principle, the structure and the main features have not changed from the 2013 version, which was really the big new arbitration rules to the ones that had been enacted 10 years before. So what we have now new in the rules is basically the equal footing of arbitration and mediation is reflected in the rules in the way that they consist of two parts. Mediation rules and arbitration rules are on the same level, because before the mediation rules would have been just an annex, and we just raised them to really show that we consider both institutes at equal to each other. The second is we introduced some issues, sort of electronic case management system, in order to be able to administer disputes more efficiently, and also taking into account that people nowadays don't send letters but send emails, and we also wanted to take this into account. Another issue is that we explicitly wrote into the rules that we want the parties and the arbitrators to have a lot of incentives to conduct the proceedings in a cost-efficient and effective manner. And I have also even means and the arbitrators to incentivize this by raising arbitrators' fees when they have been very efficient. And also the arbitrators, they have means in terms of costs where they can even sort of punish parties who drag on, who file submissions that are just prolonging the proceedings. And that was a very important thing for us, because time and money, I think that's the two issues that you've mentioned. In terms of expedited proceedings, we have opt-in mechanisms. We don't have a monetary threshold, because we felt, and I think that has been discussed very much also in the working group too, it's always very difficult to set one monetary threshold where it's justified that everything beyond falls automatically under the expedited proceedings, because also from the parties that we have in our arbitrations, they are used to much longer proceedings. So if a regular proceedings takes less than a year, this is considered fast. And I think we should not forget that fast doesn't always mean that only the arbitrators have to be fast, but also the parties have to be fast. And conducting an arbitration within 6 months needs a lot of effort also from the parties. And that's why we thought there should be a deliberate decision for this. And the respondent now has the possibility to ask for security of cost. That's also a new provision in terms of increasing third-party funding. I think we felt that this is something that is really needed. And lastly, we also overhauled the model arbitration and mediation clauses in order to provide possibilities to mix and match these two proceedings.
Well, that's great to hear about these new efficient rules, because well, you know that everyone was talking about the lost promise of arbitration, and in each interview with the colleagues from arbitral institutions, from arbitration society, we touch upon this topic. And well, I become more and more optimistic with each interview, because I hear that the institutions and so the arbitrators, they are concerned about this, and they address these concerns, I think, in a proper manner. So that's great to hear. I think it's also interesting that you talked about this equal level of arbitration and mediation rules. I think it's also maybe reflects historical role of Vienna, as you told, as a mediator between the West and Eastern world. So can you please tell a little bit more, so how this works, and how does this one-stop shop, as it's called, solution helps party to solve their dispute in a proper, efficient manner?
Well, we all know that the big criticism to arbitration is that it has become costly and long, almost like court proceedings. On the other hand, we can still see that mediation has met a lot of skepticism with the parties, first and foremost because of the enforceability issue of a settlement agreement. And in order to help parties, because we still think that, especially when you have an ongoing business relationship with your counterparty, that sometimes a mediation is probably the better way forward in order to really safeguard this ongoing business relationship. So what our idea was is that parties start out with the arbitration, because sometimes you need to file a claim in order to, for the statute of limitation to stop, and also for the other party to take you seriously, that you really mean it. But then we have seen, as soon as the arbitration claim has been filed, then the party's willingness to to negotiate starts. And we wanted to provide them with an option that they can, within the arbitration proceedings, have a carve-out, a mediation window, maybe appoint an independent mediator that solves either part of the dispute or the whole dispute, and if they so wish, they can go back to the arbitration and then ask the arbitrators who have suspended the proceedings meanwhile to render an award on agreed terms. And with this procedure, even the New York Convention remains applicable, because you have started out with the disputes, then you had your mediation, and then you still have an enforceable award. And I think in that we can enhance and maybe also help streamline proceedings or limit proceedings to only certain issues, whereas other issues can be settled. Also, we will see if that is still necessary in years to come, when the Singapore Convention on Mediation is signed by more parties and ratified.
Has Austria signed?
No, Austria has not yet ratified, but I think
same with Russia.
is following probably the European Union's advice. So we still hope that this is going to be done in due course.
So as I understand, there is no changing head problem, because the mediator and arbitrator, they do their own roles.
They do their own roles. Yeah. I mean, theoretically, it could also be the same persons, although we don't encourage this. And under Austrian law, there are some restrictions for an arbitrator to become a mediator and switching back. And also, what is the advantage is that parties stay within the same institutional framework. They are not charged a second time for administrative fees. There's no other registration fee. It's just the fees of the deciding body. And of course, if you move back to the arbitration, and basically the arbitrators have not done any work except starting the proceedings and then rendering the award on agreed terms, I also have the possibility to lower the fees in accordance to the amount of work that they have been doing.
Well, I think that the amicable settlement and the award on the consent conditions, so I think it's the best way to resolve the dispute, and it also addresses the issues of efficiency, time and money, so that's a good option. You mentioned some restrictions, and you mentioned the third-party funding issue. Just I would like to briefly touch upon this. So there are no restrictions in the Austrian legislation in regard to third-party funding, so do you see these kind of cases coming?
We see this kind of cases coming. We also see funders establishing offices now in Vienna, because Vienna is seen as a hub again as a gateway for the CEE and SEE countries. And for us, it was really important when we initiated or when we drafted the security for costs provision, and we have an extensive commentary in our handbook to make clear that the mere funding does not justify security for costs asked by respondent, because there can be various reasons why a party decides that they don't want to invest their own money. Maybe they have something better to do simply, and they don't.
Business solution.
It's a business solution. So I think that was important, and so we don't have any rules yet on third-party funding in our rules, because at that time when we drafted it, the ICA report was not yet out. And we really wanted to wait for that, but it's clear that basically the third-party funding issue is the impartiality.
Yeah, the disclosure.
The disclosure, and I think what is the recommendation that we give to our arbitrators in our guidelines is to address this question upfront, so that everyone is on the same footing. That I think the fact that third-party funding occurs should be disclosed, so for the arbitrators to be able to conduct their conflict check. But the terms and the rest of it, I think that's something that has nothing to do with the rest.
That's very interesting development, and well, I think we will discuss it further in the coming years. So there are other European institutions that are also popular among Russian users, like ICC in Paris, LCI in London, SCC in Stockholm. Can you briefly touch upon what are the main differences of VIAC to other institutions?
Well, we are all friendly competitors, and in terms of the rules, there's really not so much difference on the main levels, but still it's important for some features there are some differences. You mentioned expedited proceedings before. I think the ICC and the SEC, they both have monetary thresholds when you are under this threshold, automatically you would fall under the expediting proceedings. You would have to explicitly opt out. And as I've explained before, we have these opt-in mechanisms, with the result that, of course, we have less cases, but those cases we conduct, parties really want it and they really do it. And we also think that the way, for example, the ICC has drafted it, that even if you had 3 arbitrators, you might end up with 1 arbitrator only because you fall under these rules. We don't like to be, I think, party autonomy and parties' choice is really still very important for us, and we don't want to give the impressions that we know better than the parties for some instances. So that is one of the differences. Another is that we are very hands-on with the case administration, probably in between ICC and SCC. So we keep a mirror file which permits the case managers and myself to really monitor the proceedings, to be able also to assist arbitrators in difficult situations and have a mirror file. And sometimes it happens that you have a change of counsel on one side and, there's a fight, the counsel doesn't want to give, so we have a mirror file and we can provide the parties. Also in terms of service of the award, we have a policy that we really pay a lot of attention on the service of the award. And I always like to stress that even nowadays we are in this sort of electronic world and everything is done electronically. I think there's 2 instances where it's really important to still have paper. It's at the very beginning when you send the statement of claim, when you collect the receipt for the enforcement, and also at the very end when you receive the award and we bind the award, we put sticker, and also being part of a public legal entity in Austria, we can use the Austrian eagle, the emblem. So our awards really look very, very official. I mean, they are official and they look official, and that really helps also in terms of enforcement, which is a difference when just the arbitrators send out the award. That can be on any stationery. Also in terms of advance on costs, we really do a lot of assisting arbitrators also in terms of VAT. We also ask for the VAT, we assist them, and we keep everything on our accounts, and only at the very end we determine the costs, and this is being taken off the shoulders from the arbitrators. And lastly, we are a regional institution, so it's difficult to compare with the ICC, who is really doing business worldwide. That's why also their rules are much more extensive than ours. Our rules are much more lean and flexible because we are only dealing in a certain region where everyone is more or less on the same footing. Yeah, and we have a license to operate in Russia.
I wanted to say this, but I know one more difference, at least for now.
At least for now, exactly.
Yeah. So that's really a very important development for Russian users, that in July 2019 VIAC received this permanent arbitral institution status, which makes it even more interesting option for the Russian users, especially having some business relations with the European counterparties, and not only European counterparties. As I understand, even before this, you had a number of Russian parties in arbitrations, also Russian arbitrators. So can you please tell about maybe some figures and what you expect after after July 2019, some increase in caseload on the Russian-related disputes?
Well, traditionally, we have about, and just to set this in perspective, we have about 60 to 70 cases per year pending. And out of that, in 2015, we had 7 out of 65 Russian parties, which is, almost a tenth. In 2016, we had 9 out of 124. In 2017, 6 out of 84. In 2018, 5 of 120. So there's a steady between 5 and 10 Russian parties per year, which is almost like between 5 and 10%, which in terms of total numbers might seem low, but in terms of percentage, it's still quite high.
It reflects the position of VIAC. Yeah.
In general, I mean, we have seen an upraise in parties from the CEE and SEE countries in general. So more than a third, almost like half of the parties come from that wider region. In terms of arbitrator appointments, in 2018 we only had one Russian arbitrator appointed out of 67. There was none in 2017 and in 2016 and 3 in 2015. Again, it's not a lack of not having potential Russian arbitrators available, but of course when appointing arbitrators or when the parties select arbitrators, there's a myriad of instances that have to be taken into account. It's the language, it's the nationality of the parties. But on our sort of list of arbitrators, which is an open list, a sort of not a recommendation, but the possibilities for potential candidates to present, we have 23 Russian practitioners, nationals on the list, and more than 70 arbitrators who speak Russian. So we are well prepared for an increase of cases that we are of course expecting, but we know that these issues will take time. It's not that overnight, you know. The same with us with the domestic cases. It's not happening from day of tomorrow, but we are prepared. We have the people, you know, who would be competent to decide these disputes, and yeah, we're prepared to administer disputes when they come.
And your staff is also happy to answer questions in English
and in Russian.
As you told,
yeah, we have 2 case managers who also speak Russian, and also Czech and Slovak and Polish. So we really, you know, are in a very lucky situation that our staff is able to communicate, which is also important.
That's great to hear, and I think it will be a good option, including these like M&A corporate SPA disputes, which can be now solved also under the VIAC rules in regard of Russian companies. So for some joint ventures, some of these projects, so it can be a very good option. So transparency and confidentiality are the 2 main like central pillars of arbitration. Can you please tell how VIAC deals with it and what measures it takes to balance these 2 core interests?
Yeah, well, there seems to be an intrinsic sort of tension between the 2 instruments. On the one hand, arbitration is always sold with the label, you know, that's confidential, and that's one of the main advantages versus state court proceedings. And we shouldn't sort of forget that confidential means that just the public should not have access to attend the hearings. But confidential does not mean that nobody can ever hear anything about that case, because there is, I think, the need also for some arbitration awards, at least in an anonymous form, to be published, to, you know, set standards, to provide insights in, and also in order to increase trust in the work of arbitral tribunals. So what we have done for our anniversary in 2015, we have published 60 arbitration awards from 1975 to 2015 in an anonymized form, so that neither the parties, you know, and also as an abstract. So really only taking out those legal questions, legal questions that are important, and that really has met a lot of support from the legal community. We have even in our rules a provision that permits us to publish awards in an anonymized form if the parties have not objected against it after rendering of the award. But still we have the policy that we really don't want to do anything against the will of the parties. So when they're very delicate awards, we would always seek the consent and maybe even exchange with the parties the draft of the abstract, so they also feel comfortable that nothing is disclosed that they would not want. And I think that is really also an obligation of the arbitration institution to increase trust, that people can see that these are really high value decisions, not, you know, just a 2-pager saying, yeah, you have won, you have lost. And we're working on a second edition. Another issue, what I think is really important, is that in 2017 we have decided to publish arbitrators' names on the website, because, as I said, we are small institutions, and of course what has been said all the time is, well, you know, under the VIAC rules, always the same 10 arbitrators are being appointed, and even if we have said, well, this is not the case, yeah, that was the common belief. Now everyone can see who are the arbitrators. They can see, have they been appointed by the parties, have they been appointed by the board, and in that we also raised our diversity level. when we speak about diversity, I don't only mean men and women. This is one level, and the board is appointing about 50% women, whereas the parties and the co-arbitrators are still lagging behind. But also in terms of age, we really try to also enhance young practitioners, give them the first appointments, and of course monitor closely what they're doing. Yeah.
That's great. So I think it's very interesting initiatives, and it's very interesting to look how it works. Can you please tell a little bit about, you mentioned the new technologies in the new rules. How is case management is being done, so in the VIAC, and actually how some planned new technologies, solutions, cloud solutions, we will help to deal with case management in VIAC under the new rules?
Well, in 2018, with the new rules, we really set the step for paperless administration, with 2 caveats. As I mentioned before, I think it's important to receive still the statement of claim also in paper form. That's enshrined in the rules, but in order to start the arbitration, it's sufficient to send the statement of claim in an electronic version. And then we need the paper version in order to be able to send it to the respondent also in an original copy. And after that initial stage, after the statement of claim has been sent to the respondent and we have the receipt, from then on everything is done only electronically. Currently it's still done by email, but what we are planning for next year are 2 issues. First of all, we want to have on our website the so-called electronic postal office, where parties, when they submit the statement of claim, they don't have to send it by email, but they can just upload it on the website on the secured cloud.
Including all exhibits, which can
with
be
all
rather
exhibits,
voluminous,
which can be a lot, because I think email, we all know, I mean, that's outdated. I mean, that's so risky when you have counsels or sometimes arbitrators or whoever with a Gmail account. You can, the confidentiality becomes absurd. So this is the one issue. And then what we're also currently working on is to be able to provide parties and arbitrators for a particular case with a cloud system that they can use for the case in, uploading, downloading documents, for transmitting submissions, and after the case is being closed, also the cloud is being closed and nobody can access. Because I think this is really something in terms of confidentiality that is absolutely needed. And we have an own database and electronic case management system in place as of last year, where all the case material that we receive, all the mirror file, is stored on this database. So only at the very end, then again we need the paper when the award is being issued. But even
to
here,
put the eagle.
With the eagle, exactly, with the signature. But even here, we send to the parties upon request also an electronic version.
That's very interesting, and well, I think in the end of the day it also helps to address these concerns about time and cost, because when you have everything online, you can upload, download, so you don't have to deal with the printing out and everything.
Exactly.
So it helps to address these issues.
We make the life of some young associates much more livable, because they would be the ones, sitting and copying thousands of files,
binding,
and nobody. I mean, that is really, that's just not.
That's great, and I think that helps us to look optimistic in the future of arbitration and becoming more and more popular tool. So thank you very much for this very insightful talk. I think it was very interesting, and also I wrote down some ideas for me. So it's always great to meet you and to discuss arbitration. I wish that all the eagles of your awards will fly very successfully for the enforcement. So you're always very welcome. Thank you very much for coming, for your time, and all the good luck.
Thank you very much.
Thank you.